20.
Item number 24, my lord. In this case, my lord, the official respondents have, my lord, file an affidavit in opposition. I'll have to take some instruction, my lord. Also, the matter, my lord,
The voice is not clear. What is wrong? Yes, yes.
Lordship fix the matter immediately after vacation, my lord.
No, what is the problem? Why was it fixed today?
My lord, it was fixed for filing the affidavit by the respondents.
Have they filed it?
They have filed the affidavit, my lord. I'll
Okay,
get-
Mr. I. Sokia, learned counsel for the petitioner submits that you'd like to file rejoinder affidavit.
If required, my lord, I'll have to take instruction from my client. I'll have to take instruction from my client, my lord.
Submits that the respondents have filed counter affidavit and he would like to complete his instructions and if so advised, file a rejoinder affidavit. Matter be listed after 2 weeks. 3 weeks?
My lord. Immediately after due vacation, my lord. But suspension matter, my lord, is under suspension.
February list ko diyan eh. Sabi? February list ko, no?
2nd of February, my lord.
No. 5th of February.
My lord.
Yes.
My lord, I am also praying for listing this, my lord, contempt petition.
Hmm.
My lord, family pension matter, my lord. Since 2021, the order is not being complied with, my lord.
22 January.
My lord.
Yes.
May I please also, with the consent of other side, I beg to mention item number 42, my lord.
40?
2. My lord, standing counsel NEPCO, Mr. Debojit Senapati is suffering from severe cough and cold, my lord. He would not be able to come.
You're for the respondent.
My lord,
You have taken consent
My
of the petitioner.
my lord.
Mr. So-and-so learned counsel for the petition respondent submits that the matter be adjourned for 2 weeks as the arguing counsel for
NEPCO.
NEPCO, NEEPCO NEPCO is indisposed. He submits that consent of the counsel for petitioner is obtained. List accordingly after 2 weeks.
Much obliged. May I please proceed with the consent of the other side, my lord. Item number 44, this matter pass over for the day, my lord.
Item 44 at the request of Mr. So-and-so passed over for the day.
43.
Counsel for the petition. Yes.
May it please your lordship, my lord, in item number 26 to 34, my lord, we have filed an affidavit yesterday, my lord. I pray that the affidavit may be called for, my lord.
Yes. Call for.
May I please your lordship? My lord, I beg to mention item number 46, my lord.
Hmm.
May be
46.
taken after behavior.
46 be listed after 3 weeks. Yes.
Obliged. May I please your lordship? Lordship, with the concern of other side, beg to mention item number 18 to 21, lordship. Lordship, the respondent had to file their affidavit, lordship.
Not item to 18 to 21, item to 18 to 22.
Hmm.
I am for the petitioners, my lord. They failed to file the affidavit.
My lord, the reply is sent to the department for waiting, my lord, immediately after the vacation.
May I pray for a date now?
Don't make a submission unless you are sure. Immediately after BU vacation, you'll be able to file it.
My lord, after Bihu vacation. After Bihu vacation, my lord.
After BU vacation begins on 18th of January. Will you be able to file it on 18th, 19th?
My lord, 2 weeks, maybe. 2 weeks, my lord.
Now it is 2
Then
weeks.
what kind of a submission is this after BU vacation? We are fixing it on 22nd of January.
My lord,
We want your affidavit on record.
my lord,
You are appearing for railways.
my lord.
Your name, please.
My lord, why Borbhuya?
Why?
Borbhuya.
Borbohia, learned counsel appearing for the railways, NF Railways, submits that the affidavit could not be filed. He prays for further time. Mr. H. Omua, learned counsel for petitioner, submits that there is an urgency in the matter and a matter be listed on a fixed date. Accordingly, let the matter be listed on 22nd of January,
Obliged.
I'm okay.
by which time the railways may file their counter affidavit.
May it please
Yes.
reserve, Lordship. Also, I beg to mention item number 35 to 38, Lordship, with the consent of the respondents, Lordship. Also, we need to file fresh wakalatnama in this matter.
Item 35 to
38, Lord.
38.
I'm for the petition, Lord.
Your name
A Setia, Lord.
is A. Setia.
Yes, Lord.
Mr. A. Setia, learned counsel for the petitioners. Setia or Chetri?
Setia, Lordship.
Setia submits that he's been recently engaged in the matter. Therefore, he craves leave to complete his instructions, seeks some time to complete his instruction, at least after 3 weeks. Yes.
Please, Your Lordship, with the consent of the other side, I beg to mention item number 31, 39 to 41, Lordship. Lordship, the client wants to engage a senior counsel, Lordship. The client wants to engage a senior counsel, Lordship.
39 to 41. The client wants to engage, let him engage.
Kindly, 3 weeks time may be given for instruction.
3 weeks' time is prayed for by the learned counsel for the petitioner.
Instruction.
Accordingly, matter be listed after 3 weeks.
Lordship, let.
Yes.
Lordship, I beg to mention for listing of a WPC, the matter pertains to compassionate appointment, Your Lordship. The matter was last posted on
For admission. You want it to be listed for admission,
for orders, Your Lordship.
for orders. Fifth of February.
Obliged.
Also similar to your lordship, sometime in February, listing of a petition, Lord.
Fifth of February.
Lordship, lordship, could it be on 20th, your lordship, 20th of February,
28th,
lordship,
20.
lordship.
All right, 20 February.
May it please your Lordship, I humbly pray that this matter be passed over for the time being, Lordship. Iskeras is appearing in this matter.
All right, time being.
Obliged, Lordship.
Which is your lordship? Well, yesterday night I was given the copy of the reply. After going through the reply of the government, I find that this will be good grounds for me because they have not answered the specific query. The chief secretary restrained
You're-
from
you're-
answering the questions.
You're lucky, you've got a copy, we have not even been.
Well, I
No, no,
don't know.
copy.
Well, the
I don't
problem, they don't follow the High Court rules. They never give us copy in time.
Okay,
Its reason is very obvious.
Additional affidavit. Additional affidavit.
No, no,
No,
they
they
have
have filed
replied.
additional affidavit. We filed a counter.
What was filed yesterday?
A reply to their affidavit.
Reply.
Their
to the-
affidavit,
I
but
think-
I can start my argument because your lordship, on the last occasion, it was agreed that at least I start my, I'll
No,
take in,
That's all right, but what is there in the affidavit?
yes, my lord, if I may say, my question was that the cadre rules, the promotion has to be cadre wise, it is settled by the Supreme Court.
What is to be decided in this bunch of writ petitions?
Well, in
Let us
this bunch
understand.
of writ petitions, basically, only one issue which calls for your lordship judicial scrutiny is there. After the judgment of the single judge and the division bench, the government of Assam deliberately passed an OM overriding those these issues which were settled. And basically, they brought an OM which virtually override not only this act, the Supreme Court judgment, but also the judgment. That was
What is that OM?
Yes, that's the lordship will take up page, item number 7, where the constitutional validity of the 18/1/2023 OM was challenged. Your lordship, page 117 is the office memorandum. Yes. One factor is judgment provision.
117.
Yes, lordship, 107, lordship.
107.
This is a OM of 18 January 2023.
18 January, yes.
Yes. Lordship got it.
Yes.
Review of the government policy of reservation in promotion with reference to the Guwahati High Court's judgments. This was pursuant to the judgment, Bhagwan Patel judgment.
Hmm.
The Honorable Guwahati High Court in its judgment and order dated 6/6/2022 in WPC 505 Bhagwan Patel and Equality Forum had observed in para 7(9), Article 16(4) and 16(4)B being enabling provision, the state is at liberty to implement the policy of giving reservation in promotion with consequential seniority or without consequential seniority, or at liberty not to provide any reservation in promotion. However, while implementing such policy, due process of law need to be followed, including dicta of Nagraj and Journal. The government of Assam, after careful consideration of the Honorable High Court judgment dated such and such, had reviewed the existing procedure for effecting reservation in promotion with consequential seniority for the reserve categories and accordingly laid down the following guidelines to be followed while considering promotion to any establishment. Number one, the policy of reservation in promotion shall continue. Number two, each establishment, if I may take the offending part, Lordship will turn to page 108. Our entire constitutional validity challenge is to clause 4. A, can I read?
Yes.
In case of promotion in grade air service, the quantum of reservation of SC/ST in promotion shall be a stipulated percentage of reservation is available for such categories. However, SC/ST in Group A services on their accelerated promotion by the virtue of rule of reservation shall not be entitled to consequential seniority. The application of general catch-up principle rule will allow eligible officers who were senior in the merit list at the entry level in Group A services to regain their seniority in the promotional cadre. Once they are promoted to the same cadre as an officer of reserve post category, provided the officers of the reserve category had got their promotion ahead of an officer belonging to them in the merit list, by way of accelerated promotion on account of reservation in promotion in a particular cadre, seniority of the government servant in age shall be revised accordingly as per the above principles. Further, an officer promoted from B to A service will also regain his seniority in Group A on promotion vis-a-vis his compatriot in B, provided that the officer was senior to the reserve post office category officer in the category B cadre. Prior to the promotion of the reserve category officer in Group A, seniority of such B government servant appointed to Group A service shall be revised accordingly. Last part. If any occasion arises during the promotion process in Group A service in which the stipulated percentage in respect of reserve is met in the next promotional cadre, great. But in the zone of consideration, this candidate of reserve category who on merit are entitled to promotion, the case shall be considered for promotion on merit if such candidates have not made their zone of consideration by way of any accelerated promotion either by virtue of rule of reserve. Well, this clause was challenged on the ground. Your Lordship will now come to the operative part of the judgment of Bhagwan Patel, because our challenge is that the judgment was now overruled by this OM. How I'll specify. Your Lordship will come to the operative part of Bhagwan Patel's judgment at page 103.
Yes.
D, down below, whether clause 4 is violative of section 5 of 78 and therefore liable to be struck. The entire challenge was clause 4, the offending clause. Clause 4 of the offending office memorandum provides that in a given situation when the percentage is achieved, but some reserve category who on their own merit are entitled to promotion, his or her promotion shall be considered on merit, subject to the further condition that such person has not gained any seniority by way of accelerated promotion. Thus, from a reading of clause 4, it is clear that consequential seniority is withdrawn for those members of the SC/ST who are eligible for promotion on merit. This is our case, but has got accelerated promotion. The said clause nowhere declares that the policy of consequential seniority shall henceforth not be applicable in all the promotion made under section 5 of the Act. This being the position, this court unhesitantly holds the policy of providing reservation in promotion with consequential seniority being holding the field as per OM of 12/3/2002 the state is not within its competence and jurisdiction to deprive such service benefit to a meritorious reserve category candidate, and that too without expressly bringing such policy by superseding the benefit given under 12-3-2002. The aforesaid determination can be summarized in the following manner. The policy of reservation in promotion with consequential seniority is discernible from Section 5 of the Act, read with 12-3-2002. Here I will add that the OM of 12-3-22 is in pursuance to the Parliament's constitutional amendment of 85th, which gives the benefit to the reserve. Next, the office memorandum dated 12-3-2002 shall hold the field till such policy is expressly repealed by the state. OM dated 3-6-2006 is notified laying down the procedure for collection of quantifiable data on backwardness and inadequacy of representation and determining seniority efficiency while giving effect to the policy of providing reservation. Given the dicta of Jarnail Singh, the OM dated 3-8-16 cannot sustain as far as the same relates to collection of data on backwardness. The determination of cadre as a unit, Lordship, cadre is the most important word, for collection of data is laid down in the OM of 3-8-16, conforms to the mandate of Jarnail and Nagraj, and therefore is upheld. The procedure as laid for determining efficiency in administration not being arbitrary, not being based on extraneous consideration, the same is upheld. Article 16(4) enables the state to carry forward vacancies, and vacancies carry forward cannot be included in the ceiling limit of 50% of the year of filling up vacancies. Article 5A of the 78, Section 5A of the 78 permits carrying forward vacancy, and therefore the policy of carrying forward as provided in the office memorandum of 3-8-16, not being arbitrary and not being based on any extraneous consideration, is upheld. Giving the dicta of Jarnail, the judgment made in the Equality Forum relating to collection of data to determine backwardness has become redundant. Next, Article 16(4) and 16(4)B being enabling provision, the state is at liberty to implement the policy of reservation and
Redundant
promotion.
means overruled, impliedly.
Malan?
What is the meaning of redundant?
Is redundant means the after the
Impliedly
Jarnail
overruled.
Singh's case, there is
Impliedly
no
overruled,
requirement of getting backwardness, quantifiable data on backwardness.
which means it is impliedly overruled.
Yes.
It's to be understood to be impliedly overruled
Overruled.
in view of the Supreme Court
Yes.
judgment.
And as regards the, yes, then 16(4)A and 16(4) being enabling provision, the state is liberty to implement its policy of giving reservation and promotion with consequential seniority, at liberty to provide for reservation and promotion without consequential seniority, or at liberty not to provide any reservation in promotion. However, this is important, Lordship. While implementing, adopting, changing such policy, due process of law need to be followed, including the dicta of Nagraj and Jarnail, and that is the law till date. The impugn OM is interfered to the extent indicated. The two questions are answered. Rest the matter. But my submission is that after the judgment was passed, the clause 4 of the offending clause of 16 gets overruled, and the Supreme Court's judgment of R.K. Sabharwal was upheld along with Jarnail and Nagraj. The position was settled. The respondent authority, the general went on appeal before the Supreme Division Bench. The Division Bench, keeping this clause 4 intact, said that when promotions is to be affected, it has to be cadre-wise. But Assam government during the time did not want to implement this.
Where is the judgment of the division bench?
Yes, the Division Bench order last occasion I've given the judgment. Lordship.
Yes, we have it. The written in
Yes.
46.
Yes, Lordship.
Yes.
Malat, in fact, here I'll just elaborate one thing. The entire argument of the state, supported by the respondent council's argument, was that the 2002 OM is now overruled because of the certain OMs of 16 and 14. The Guwahati High Court, both in the single and the division bench, negated this argument. So this argument is not there. It says the 2002 OM is holding the field, means the roster section 5 of the 78 Act giving the benefit of accelerated promotion and consequential seniority cannot be touched under any situation. Because if you touch that, you touch basically Article 16(4)A, which has been upheld in Nagraj's case. So what has happened, we expected the Assam government to comply with the order and make promotions.
No, what finding was arrived at by the division bench?
Malay, the finding that was arrived at was.
This division bench had
Yes.
examined this judgment which you had
Yes,
just read out,
Yes.
single bench judgment.
yes,
This,
and para 39 was the main.
thirty-nine,
Yes. This para 39,
yes.
yes. Malot, the said provision been read out by the constitutional bench, judgment of the Honorable Supreme Court, which read together with the provisions of the judgment in equality forum. One, it has been understood that there would be no further requirement under the law for any collection quantifiable data to substantiate backwardness of the reserve, inasmuch that there is a presumption as regard existence of backwardness. Further, we also have to take note that in the paragraph 47 of the judgment of the Honorable Supreme Court in Jarnail Singh 2, it has been provided that the adequacy of inadequacy of representation of reserve category would have to be determined cadre-wise. This is the main hunch, service-wise and in the given relevant department. The said provision is also considered with the provision in paragraph 74 of the judgment in equality forum that the collection of data regarding inadequacy or adequacy of representation would have to be cadre-wise, service-wise and department-wise. Because there the problem arose, because what had happened during the time when the judgment of Khattar was in existence, instead of implementing the judgment, they went and what they did in the OM of 2023, well, it is unheard of. They brought the same 16 offending clause added here and added a new more thing, a concept of catch-up. Well, a catch-up
No,
principle.
what we want to know is, whatever
Yes.
you read in the single judge's judgment,
Malad,
whatever you have read in the single judge's judgment, what happened in the appeal? Was it interfered? Was it upheld?
it was never interfered. It rather added the judgment
so you
towards the end.
Point out
It added certain more
we
areas.
want to understand what was
Yes,
added.
yes. Malad, then your lordship, I'll have to go through. Lordship will have to go through the operative part.
Yes, yes. Take
Lordship,
us.
what has happened? If I may cut it short, your lordship will take up paragraph 37.
37, okay.
Yes.
Yes.
I don't want to trouble your lordship from 1 to 36. Malad, what has happened, if I may say, the respondent authorities, the state never went on appeal. The respondent authorities were the general, they went on appeal. And their main contention was that you SC/ST will get promotion, but you will never get consequential seniority. For a simple reason, their logic was that a catch-up policy, catch-up principle is there. My entire ground was the catch-up principle has been nullified by the 85th Amendment of 2022. Entire country, including the central services, follow that. Means when a reserve goes on promotion, he will get all. But the Assam government, taking a cue from a paragraph stating that the state will take a decision on it, forgot to implement the Nagraj and Jarnail Singh law. As a result, this argument was basically hinging on whether there certain clause 1 and clause 14 of an OM of 14 was overriding the 2002 OM. Malla Lordship will come to paragraph 37. Accordingly, it has to be concluded. Means this is the finding of the division bench.
Hmm.
Because the main area, the bone of contention was whether the 2002 is withdrawn. I say it was never withdrawn. They say it's withdrawn. The judges finding, division benches finding accordingly, comma, it had to be concluded that the conjoined reading of clause 1.11 and clause 14 of the memorandum dated 29/12/14 would mean that the consequential seniority that was otherwise meted by the office memorandum of 12/3/2002 has not been withdrawn. So this is a categorical judgment which basically uphold the Bhagwan Patel judgment on the point of existence or non-existence of the OM of 12/3/2002, because that OM gives the benefit of the 85th Amendment to us. Because if we get a promotion and we don't get the benefit of our accelerated promotion seniority, then nothing happens because we will never get into higher posts. That was the game plan. So in fact, through the OM which overruled Bhagawan Patter, the Assam government last year specifically brought the same principle into existence. Clause 4, they brought it, and they brought in the concept of grade and services groups. This is the reason I was challenging the Chief Secretary's order. Chief Secretary has not only flouted the judicial orders of the division bench, single bench, and Supreme Court, he has till now failed to answer also why is he using the word grade when the orders are cadre-wise. Then your lordship will come to the operative, another part, 44.
Hmm.
This is 43, बोला? 44 नहीं? नहीं, कहाँ पे उठते हैं?
Yes.
Promotion to the side. Well, if I may read 44 and 45, Lordship, this is the another important area. Now, as regards the implementation of clause 4 of the office memorandum dated 3/8/16, we again quote the said provision. This is the offending clause. If an occasion arises during the promotion process in which the stipulated percentage in respect of reserve is met, but in the gradation list, seniority, there are candidates of reserve who on merit is entitled to promotion, his or her case will be considered for promotion on merit if such candidate has not gained a seniority by way of accelerated promotion. Lordship will come to 45. A reading of clause 4 makes it very discernible that if an occasion arises during the promotion process in which the stipulated percentage in respect of reserve is met, but in the gradation list, seniority list, there are candidates of reserve who on merit are also entitled to a promotion, his or her case are to be considered for promotion on merit only if such candidate has not given seniority by way of accelerated promotion. It would mean that if a reserve candidate is seeking for a promotion against a post in the promotional cadre, which is earmarked for a reserve category, he would be entitled to the benefits of consequential seniority as provided in the office memorandum of 12/3/2002. But on the other hand, if the posts earmarked for the reserve are already exhausted by being occupied by the reserve candidate, but in a gradation list, there remains some further reserve category candidates, they can compete for promotion against the unreserved post, but in such event would not be entitled to the benefits under the consequential seniority. And on the other hand, Mala, this is important, if on the basis of their seniority, that is SC/ST, otherwise, without taking note of consequential seniority, they are within the zone, such candidate will be considered for promotion. Absolutely in terms of R.K. Sabharwal. Because when we go higher, we don't want consequential seniority because we have already gained seniority ahead of the general because we go up higher as per roster. So when we go to the cadre, our seniority has to be assigned there, and that is the rules. Well, the funny part is, till this OM of 16 and 18 was brought, 23 was brought in, the Assam government was very rule compliant. It always considered seniority in terms of cadre. So we were getting a promotion. It is problem started in 16 when they wanted to deny us. And after the judgment, Lordship, the rules are very specific. In fact, the engineering rules, which many cases of the engineering service, the Assam civil service rules, the civil service rules are basically perimetry.
This interpretation of the division bench
Yes.
is in respect of clause 4 of the 16
Clause
memorandum.
he has elaborated it further, rightly so, because our entire case was.
And
when
what is being challenged here?
Yes, here we have challenged that when the law is clear that the promotion has to be cadre-wise, you bring down our seniority on a catch-up principle, which is a dead principle. Some brazenness. There is a limit to some brazenness. The Assam government in the OM gives a dead principle.
Let us see the OM.
Yes. Lordship likes to see the 23 OM. In fact, what they did, they have repackaged it and brought in the same thing. Well, we cannot allow judicial orders to be overruled in this manner, that too through an OM. I understand they withdraw the 78 Act. I understand the reservation is finished in Assam. But the 78 Act is operating, but we will not give you any benefit. Lordship will come to the OM of 2023. 18-1, page 107.
Yes,
Your Lordship will come to page 108.
108.
Clause 4 down below.
Yes.
If an occasion arises during the promotion process in a group in which stipulated percent in respect of reserve is met in the promotional cadre, grade, there is the confusion. They are using grade, new word. But in the zone of consideration, there are candidates of reserve who on merit are entitled to promotion. Their case will be considered for promotion on merit. If such, if their case will be considered for promotion on merit, if such candidate had not made into zone of consideration by way of any accelerated promotion, either by virtue of rule of reservation. Is it not the same as clause 4? No, what more is required? In black and white, you bring the same thing. And now what they did, they categorize it into two groups. And there, the groups are group A, you will get all the, you will not get the benefit of seniority. Groups B, C, D, you will get. Means from down below, in the clerical level, we will be given everything under the constitution, accelerated promotion, consequential seniority. But when we go up, our seniority will be taken away. Where they are basically making a class within a class, which is impermissible. There is no intelligible difference here. It is arbitrary under Article 14. What more is that necessary? And they bring in the redundant catch-up principle. Lordship will read the first part, clause A, clause 4. I mean, in fact, this affidavit is helping me, the government's affidavit. Lordship will come to clause 4A. Can I read?
Yes.
In case of promotion on group A class, A service, they have brought in, categorized. The quantum of reservation of SC, SC and HE in promotion shall be a stipulated percent of reservation available for these categories. However, SC and ST, STPH servant in group A service on their accelerated promotion by virtue of the rule of reservation shall not be entitled to consequent. Same repetition. The application of general catch-up rule will allow, this is something too much, will allow eligible officers who are senior in the merit list at the entry level in group A to regain their seniority in the promotional post once they are promoted to the same cadre as an officer of reserve, provided that the officer of the reserve had got his promotion ahead of an officer senior to him in the merit list by way of accelerated promotion.
Para 45
Yes,
of the judgment,
yes.
is it a finding or is it
Malad, what?
an interpretation of clause 4?
Malad, it is an addition because what has happened in the Bhagwan Patar.
We want to know para,
Yes.
para 44 reflects the clause 4.
Yes, it reflects
Now,
that
what
on
is,
merit
what
you
is,
cannot deny.
what is para, how is para 45
Yes.
to be read? Is it to be read as an explanation of the court understanding clause 4? Or is it a finding of the division bench?
No, it is.
Insofar as clause 4 is
it
concerned.
It is an elaboration of the finding of the single bench. It's an elaboration. The reason is, Malad, we were denied the merit and
So
we
you-
cannot be denied the merit as we go up. And as we go up, we don't want the concept of consequential seniority. So the division bench says that if you are within the zone, you will be considered. Our problem comes in when they have brought in the catch-up principle.
That is what we want to know. Has the division bench said it or is it merely a rendition of the clause itself?
Malad, the division benches upheld the single bench's order with this elaboration. Because ultimately, one more thing the division bench said, which the single bench did not delve into, that the promotions have to be cadre-wise, because our entire case is hinging that if it is cadre-wise, Malad, the benefit of the seniority which we got earlier in each cadre, we get it. Because now by bringing the catch-up principle, which is not there in the constitution, how can you justify? Malad, till now, the affidavit which has been filed by every officer, including the yesterday another personnel department, they said that because of catch-up you were brought down. Malad, it's not that easy. This principle of catch-up is gone in 2022. The Assam government cannot take up something from the grave and give a benefit to some class. This is what they have done. And virtually, it's the same OM which they brought it. Lordship will see, they only made it into two parts, clause A, class B. What is the concept of groups? Like, groups are not envisaged. If your Lordship, when I go to the judgments, the journal thing says, if you bring class and groups, ultimately you will have to take the entire service as a unit, which you cannot do. Now, what the Assam government has done for the general, seniority will now be assigned as per your APSC list 30 years back. Because the general were always senior to us in the initial cadre, we jumped up and went up the cadre. But if the rule provides for that, can we be faulted? That is our case. For 20 years, we went up, there was no problem. The Assam government was complying with the rules. Suddenly from 16, they had a feeling that we will now start depriving you with certain OMs. OM has to be in consonance with Act and the rules and the Supreme Court judgment. The OM now is virtually abrogating everything. That is our case.
Yes.
And in fact, in all the two judgments, your Lordship will find that the Supreme Court, Guwahati High Court judgment was in compliance with Supreme Court judgment. In two forums, they have not been able to explain where the catch-up principle came and whether the journal thing is in their favor.
Okay, let us come back to clause 4 again, 108.
Yes. Well, the amendment was the same.
Yeah, 108.
Yes, clause 4. In case of promotion in Group A services, the quantum of your Lordship. In case of promotion in Group A services, the quantum of reservation for SC, STP, STPH in promotion shall be as per stipulated percentage of reservation is available for these categories. However, SC and STP and STH government servants in Group A on their accelerated promotion by virtue of the rule of reservation shall not be entitled to consequential seniority. The application of general catch-up rule will allow eligible officers who were senior in the merit list at the entry level in Group A to regain their seniority in the promotional post once they are promoted to the same cadre as an officer of reserve category, provided the officer of the reserve category had got his promotion ahead of an officer senior to him in the merit list by way of accelerated promotion on account of reservation in promotion in a particular cadre. Seniority of the government servant in clause Group A service shall be revised accordingly as per the above principle. So they could not till date in any affidavit satisfy and say that the catch-up principle is there. They are feigning ignorance. Well, they are not answering that thing. In fact, yesterday's affidavit also brings in the same thing. We brought you down because of catch-up. You brought us down because of catch-up, but we are above you because of the rules. Now the OM, it's an incongruous situation. If the OM is to be given effect to, the rules will be violated, the Supreme Court judgments will be violated, and the division bench and the single bench's judgment will be violated. Where do we stand? That is our simple case. And secondly, Lordship will find
Yes.
that in the last part, it is suffering from legal malice of the highest type. It's a fraud on power. Last paragraph we'll say, find clause 6. Down below, this office memorandum is issued in supersession of OM of 2002 and 2016. Well, I understand 2016, they have reviewed it, their understanding of the judgment, but well, Lordship will see the mischief. 12/3/2002, which is still valid, because if they say that the Assam government has withdrawn it, you make a statement before the, you make a public statement that the 78 Act is gone. Totally, you are abrogating 78 Act because power flows from 78, and that has been Bhagwan Pata's judgment. Section 5 gives that power. And second ground of attack is that Group A services, B, C, D, you cannot categorize it because grouping as per grade is impermissible as per paragraph 47 of Jarnail Singh. Jarnail Singh 2 has elaborated it, because if you don't give cadre promotion and you take the length of service of an officer, the reserve will never get any promotion in the future because they have been brought down. And the Assam government now has opened up a new column. Malad, you open up columns, new columns, but it has to be compliant also, saying that date of entry into service, initial service. But what is this alien concept?
Let us go to the 2002 memorandum.
Yes, yes. Lordship, the 2002 memorandum, OOM, page number 46. 12th of March 2002. Can I read?
Yes. yes.
Fixation of seniority of reserve vis-a-vis general in promotional post. Consequent upon the amendment of Article 16(4) of the Constitution of India by the 85th Amendment 2001, it has been decided that the following principle of fixation of seniority of reserve vis-a-vis candidate in promotional post shall be followed. Scheduled caste, scheduled tribe candidates, servants shall on their promotion by virtue of the rule of reservation roster will be entitled to consequential seniority also, and the above decision will be effective from 17th of June 95. Well, it was given retrospective effect. On the basis of the reserved seniority, consequential benefits like promotion, pay, pension shall be allowed to the concerned SC/ST candidates without arrears by applying no work, no pay. For this purpose, senior scheduled caste, scheduled tribe candidate servants may be granted promotion with effect from the date of promotion of the immediate junior. Other OBC, such promotion of scheduled caste, scheduled tribe may be given with the approval of the appointing authority of the post to which the government servant is to be promoted at each level after following normal procedure of departmental selection committee and with approval of the Assam Public Service Committee. Last part is important. Except seniority, other consequential benefits like promotion, pay, including retirement benefit in respect of those who have already retired, allowed to general OBC servants by virtue of implementation of the office memorandum dated 12/6/96 and in pursuance to the direction of the Assam Administrative Tribunal shall be protected as personal. The instruction contained in this department office memorandum of 12/6/19 stands withdrawn with effect for 12/6/96 itself, and seniority of government servant determined in the light of the above memorandum of 12/6/96 shall be revised as if this office was never issued. Well, this is the important. This is, Lordship will come to the earlier page, page 44. Malad, the OM of 2096 was the catch-up principle, which the Assam government withdrew it. Well, Lordship will find the mischief here. This is a letter of 12th of June 1996 by the Assam government through the personnel department. Fixation of seniority of candidate vis-a-vis general candidate in promotional post. The Supreme Court of India in its judgment dated 10/10/95 as reported to in 695 Supreme Court 6 SCC in Virpal Union of India versus Virpal Singh Chauhan and others have held that when the reserve category entitled to, while the reserve categories are entitled to accelerated promotion, they could not be entitled to consequential seniority. While the rule of reservation shall be applied and the roster followed in a manner of promotion to or within a particular class or category, the candidates promoted earlier by the virtue of the rule of reservation roster shall not be entitled to seniority over his senior in the feeder category, and that as and when a general candidate who was senior to him in the feeder is promoted, such general candidate will regain his seniority over his reserve candidate, notwithstanding that he is promoted subsequent to the reserve candidate. This principle would be operative from February 10/95. It is therefore decided that the fixation of seniority of reserve vis-a-vis general in promotional post in accordance with the above verdict shall be followed by the concerned while making the list all eligible class service of employees. The seniority of officers so fixed in the above principle will be effective from 10/95. Lordship will come to page 46. Down below, the instruction contained in office memorandum is 12/6/96 stands withdrawn. My lord, it stands withdrawn from 12/6/96. And seniority of the government servant determined in the light shall be revised as if no memorandum was ever issued. Well, Lordship will see the mischief. The Assam government, knowing fully well that the personnel department issued a OM of 12th of June 1996, bringing in a catch-up principle and withdrawing it by the OM of 2002, did not inform this court that how could they have brought this same OM, dead OM, in the OM of 2023. Well, what more is required? To the back door, the personnel department, because Manoj, the entire genesis of all the problem is the personnel department. The department never has done any cadre promotion in the entire civil service. Well, it is shocking. Possibly no officers came in earlier. It's by providence then my clients came in and we are wanting this under judicial scrutiny. Well, if the catch-up principle is nowhere in India, from where did the Assam government got this on 2023? Because by that principle, you are basically taking our vested right of promotion, which we gain under the rules in the promoted cadre. And they made sub-categorization into A, B, C, D, which you cannot do. Well, the Assam government might not give benefit to the SC, STs of Assam, but the Assam government must also know that they are also under a rule of law and a law, and the law is totally against them. Neither any Supreme Court judgments is in their favor or any High Court judgment. So my contention is that categorization now, bringing in the same catch-up principle and bringing in the same clause 4 is basically overriding a judicial decision. Well, judicial decision is final. The state of Assam has never gone on appeal before the division bench or the Supreme Court. In view of that, well, this office memorandum should be quashed and we should be assigned our rightful seniority in terms of the refix seniority cadre-wise. That is our prayer. In fact, Lordship, if I may take your Lordship to the Jarnail Singh case, which is, in fact, the Supreme Court is monitoring also at this present. Lordship will find paragraph, I'll just won't trouble the Lordship with a judgment. At paragraph 47. At least the first half. Well, the state should justify, paragraph 47, Lord.
Yes.
The state should justify reservation in promotion in respect to the cadre in which promotion is made, taking it into account the data pertaining to a group, which would be an augmentation of certain cadres in a service, would not give the correct picture of the inadequacy of representation of SC and SC in the cadre in relation to such reservation in promotion is sought to be made. Rosters, this is my anchor sheet. Rosters are always prepared cadre-wise and not group-wise. In my case is that the Assam government by this OM is making group-wise. Sampling method which was adopted by the Ratna Prabha committee may be a statistical formula appropriated for collection of data. However, for the purpose of collection of quantifiable data to assess representation of SC
Mr.
and SC.
Das,
Yes.
what you are essentially submitting is that the state government
Yes.
is trying to find out the total number of reserve category across all cadres.
Yes. Well, what has happened? It has now, it does not believe in cadre. It says your cadre.
What is the meaning of group wise?
Yes, group wise means they take the entire service into. Means what has happened? When I go to a cadre from assistant, Lordship has rightly asked me a question yesterday. Today I'll elaborate further. Suppose I am in the cadre of assistant engineer to the cadre of executive engineer. I am qualified, I go up that cadre. When I go up the cadre, my seniority will be assigned there. Now the Assam government said, no, sir, the catch-up principle we are reviving and we will take the seniority of the initial entry into service. Once they take the service, initial entry into service, the general gets the benefit because all generals are senior to us in the feeder cadre. Always, we go up cadre-wise, we get the roster promotion. So you take the entire as a group. Supreme Court rightly said you cannot do it. If you do it, you are bringing an alien concept because you are in the process violating the rule. Because the rules, if I'll specify, when I elaborate on the rules, all engineering service rules envisage SES also cadre-wise, gradation list cadre-wise, seniority cadre-wise. Now, all of a sudden you say no cadre wise, date of entry into service. And ultimately, we all lost our seniority. Now, from one, I'm in 20, 21, I'll never get any post in the higher cadre. And in fact, this was the reason, your lordship will come. Lordship has asked me a very pertinent question, which I need to answer. Your lordship will find that in the Bhagwan Patta's judgment, the honorable court was referring to the purpose of bringing the 85th amendment. Nagaraj. Lordship, I will take it. Yes, Lordship. Your Lordship will come to Nagaraj, Lordship. Okay. Yes, your Lordship will come to 84. Mala, the interesting part is that a judgment of the Supreme Court which was overruled by a constitutional amendment is sought to be revived by the Assam government. From where they got their authority, an opinion only they know. Mala, the Lordship will come to page 84. Can I read, Lordship?
Yes.
In fact, Bhagwan Patta's 84 talks about this issue. Lord, your Lordship will come from 83. The single judge elaborates. Consequential seniority and catch-up rule.
Yes.
The Honorable Apex Court in Virpal Singh Chauhan held that a senior general candidate, has your Lordship,
Yes.
who is promoted to a higher post at a later point of time, when a junior reserve category candidate promoted being a reserve candidate, the senior shall regain his seniority over his reserve category. Junior in the promoted post, such is known as catch-up, which the Assam government is now bringing. A similar principle was approved in the decision of the Honorable Apex Court in the case of Ajit Singh 1. It was held in Ajit Singh 1 that reverse discrimination is to be avoided by maintaining a balance. The Honorable Apex Court in the said judgment further held that giving seniority to a reserve category candidate over a senior category candidate based on roster point would violate 14 and 16. A contrary view to that of Virpal Singh Chauhan and Ajit Singh was taken by the Honorable Supreme Court in Jagdish Lal in Haryana versus Haryana. Subsequently, in Ajit Singh 2, the Constitution Bench of the Honorable Apex Court upheld the law laid down by Chauhan and Ajit Singh and overruled the decision of Jagdish Lal. Thus, the catch-up rule was approved by the Constitutional Bench in Ajit Singh 2. Thereafter, the Parliament in its wisdom enacted the Constitution 85th Amendment 2001. The statement of objects and reasons of the said amendment discloses that as the scheduled caste and scheduled tribe has been enjoying the benefit of consequential seniority, this is our case, on their promotion based on the rule of reservation, the judgment of the Apex Court in Virpal Singh Chauhan and Ajit Singh has adversely affected the interest of the government servant belonging to the reserved scheduled caste and scheduled tribe category in the matter of seniority on promotion to the next higher grade. The said objects and reason further discloses that the government has reviewed the position and to protect the interest of the government servant belonging to SC and ST have brought in the amendment of 16(4)(a). The said constitutional amendment was proposed to be given effect from 17 June 95, similar to the earlier. The said amendment reads, in Article 16(4) of the word, in matters of promotion to any class, the word in a matter of promotion, comma, with consequential seniority to any class shall be substituted. So the Virpal Singh Chauhan judgment was overruled. After such amendment, the Office Memorandum of 2002 was issued incorporating the decision of the state of Assam and the principle of fixation of seniority was brought in. Well, this OM became a board of contention because from 16 onwards, the Assam government thought it that if we can bring in the catch-up principle by the back door, we can give some benefit to the general who are not entitled to in terms of the 85th Amendment. So they brought it. In fact, your lordship will find now it is very clear that the 2023 OM expressly brings the word catch-up principle. catch-up principle. And secondly, the Assam government's affidavit yesterday, last night, also refers to catch-up principle because they don't have any answer. So the best possible way is to now say what they are saying in their affidavit in opposition, oblivious of the fact that the catch-up principle is nowhere in this country. In fact, the state will go in history as a state which has brought a redundant principle, and in fact, they have overridden the rule. So my contention, my submission is that in view of the categorical submission, constitutional amendments of 16(4)(a), there is no catch-up principle. So this OM has to go because it has brought in catch-up principle, means it wants to take it to the pre-Virpal Singh Chauhan state, because Virpal Singh Chauhan basically gave the benefit to the general, the catch-up principle. And the parliament thought it, if we are to follow Virpal Singh Chauhan in exercise of our power of constituent power, we'll have to overrule this. And how we do it? Through a constitutional amendment. So-
Is this amendments,
Yes, this has been upheld.
notification, objection, reason, is it available here?
Yes, yes, it is. Lordship has very pertinently asked. Your Lordship will take up Nagaraj's judgment of, you have given the list of these, 2006, 8 SCC, there the objection reasons are there. The Lordship has absolutely asked the right. It is there.
Yes, Para.
Para 89. In the judgment, SCC, I am referring from SCC. Para 89, the objection reason as to why this 85th was brought in. In 2006, 8 SCC, page 214.
Yes.
Can I put some water, Lordship? Lordship will come to page 89.
Hmm.
Can I read?
Yes, please.
We quote herein the statement and objects and reasons of the text of the 85th Amendment of 2001. The government servant belonging to the SC and the ST have been enjoying the benefit of consequential seniority on their promotion on the basis of rule of reservation. The judgment of the Supreme Court in case of Virpal Singh Chauhan and Ajit Singh Janeja, which led to the issue of the OMF 3197, has adversely affected the interests of the government servant belonging to SC/ST in the manner of seniority and promotion to the next higher cadre. Great. This has led to a considerable anxiety, and representation has been received from various quarters, including members of servant belonging to SC/ST. The government has reviewed the position in the light of the views received from various quarters, and in order to protect the interests of the government servant belonging to the scheduled caste and scheduled tribe, it has been decided to negate the effect of OM 3197 immediately. Mere drawal of OM dated 3197 will not meet the desired purpose, and a review or revision of seniority of the government servant and grant of consequential benefit to such government servants shall all be necessary. This will require amendment to Article 16(4) of the Constitution by virtue to provide for consequential seniority in the case of promotion by virtue of the rule of reservation. It is also necessary to give retrospective effect. Lordship will see retrospective from the date of coming into force of 16(4)(a), that is 17 June 95. The bill seeks to achieve the aforesaid object. Short 85th Amendment, down below amendment. In Article 16 of the Constitution, in clause 4A of the word in matters of promotion to any class, the words in matter of promotion with consequential seniority shall be substituted. Reading this 16(4)(a), nothing in this article that prevent the state from making any provision for reservation in promotion with consequential seniority to any class or class of post in the service under the state in favor of the SC/ST, which in the opinion of the state are not adequately represented in service under the state. The question in the key case concerned the width, so this is not required. So basically, this was the reason that Virpal Singh Chauhan's case will take the seniority of the reserve and they will never be able to go up because the Lordship knows reservation is a mode of achieving equality. And until and unless reservation, these affirmative actions, and in America, they call it race. Here we call it caste. So basically, if this is not done, no senior persons will give her, and it has exactly happened. The personnel department has made the OM in such a manner that no SC/ST candidates will go up. Now what has happened? They have taken the entire cadre, entire service as a unit, flouting Supreme Court judgment of Nagraj and Journal, resulting in what? The promotions are being given left, right, and center, and all have gone up. My lord, when I came before the court, the government took up the plea, made matter is sub judice, it will take some time, we will go on forward. Well, resulting in I'm going down. One of the person who is a senior ranking secretary, he was supposed to be the commissioner, rank 1, he goes down to 24, he is retiring after 5 months. For no fault of his, because for the past 25 years, he says he did not face any problem. He was getting his accelerated promotion and consequential seniority. So I urge upon your lordship that this is a classic case where an OM has totally, in exercise of powers, bona fide exercise of power, that is legal malice.
What was the finding of Nagraj
Yes, the finding was very
in
simple.
respect to this?
Nagraj delved into two issues. One was the constitutional validity of 16(4)A and 16(4)B, and it talked about the extent of power. What is the extent of power? Towards the end, the Supreme Court upheld the amendments of 16(4)A and 16(4)B. Means the Supreme Court in clear terms says that the accelerated promotion and consequential seniority is the law of the country. And it added something that if there is an excessive reservation, you need to have quantifiable data. And that quantifiable data issue is not before us. There is no excessive. We get it as per the prescribed percentage. In Assam, Lordship knows, in a 100% roster, 100 posts are for the general and 22 for the reserve. 78 for the general and 22 for the reserve. Malad, in fact, because of this OM now, I possibly feel that the Assam government wants to give the 22 to the 78, making it 100%. They have, the Assam government is a peculiar situation. The 78 Act, it is there, but they will abrogate the operation.
What is the subsequent view of the apex court?
There is no, this part is.
Kindly listen to the query of the court.
Malad?
What is the subsequent view
Yes.
held by the apex court
Yes.
vis-a-vis the view held at para 123 of Nagraj?
Yes, Malad, the Supreme Court judgment on Nagraj was only looked into on one ground, because the Nagraj judgment, after upholding the 16(4)A amendments, added
Let
that.
me
Yes.
rephrase the question.
Yes, yes, yes.
Would it be proper to say,
Yes,
would it be proper to say
yes,
that the amendments which were challenged in Nagraj,
yes,
16(4)A,
yes,
with regard to consequential seniority, etc., was interpreted by Nagraj as done in para 123?
no, no, my lord. There were two issues before the Supreme Court. What is the constitutional validity? Whether Equality Forum had brought in that by this amendment.
No, then you have to come to 121.
Yes.
That's where the conclusion is.
Yes, but 123 talks about the, I do understand, it talks about the extent of reservation. It says that if it is excessive, your lordship, then I'll be reading the paragraph 119 also. Because in that case, the issue was what is the extent of reservation? The Supreme Court says that on the issue of reservation, 16(4)A is the law, but as regards the extent, we are adding 3 riders. What are the 3 riders? You have to have a data on the backwardness. You have to have a data on the inadequacy of representation. You need to have a data on the efficiency.
All right. Now efficiency will leave up.
Efficiency will not go because the
Right.
division pencil, it's a racist. You can't say.
Right.
Because when we go up, we go on merit. We compete. and the backwardness is gone.
Now,
as per journal.
how is this data of the requirement of
Yes, requirement
up
of
those.
data is from the cadre we find out what happens when a promotion process starts. The selection committee is informed by the appointing authority government, says that in this cadre we have so many vacancies. And you find out the percentage of.
See, the simple arithmetic is there is a roster point.
Yes.
As per the roster point, whoever is available will have to go.
Will go.
If they're not available, it gets carried forward.
Yes, it's carried
Right.
forward, and another.
Now the question is,
Yes.
what happens how do you calculate those candidates who fall into the creamy layer?
No. Creamy layer thing is not applicable to SC and ST. Creamy layer is only for the OBC. Because Supreme Court has clarified in Journal Singh 1, creamy layer is not to be brought in with SC, ST. Because what
So
happens?
in that context,
Yes.
how do you now analyze the division bench judgment?
How do
Para
you?
45.
Malad, my reading of para 45 is that first of all, the division bench judgment has not overruled any of Bhagwan Patar's judgment to the extent of the merit part, because the division bench judgment also looked into whether clause 4 was permissible or not. So the fact that in the argument it rejected the government and the private respondents' argument that the OM of 2002 is not withdrawn. It is still in operation in Assam. You cannot deny the benefit of consequential.
Therefore, we are asking you
Yes.
because you are tracing the right or tracing the requirement of the OM 2002 with effect vis-a-vis the amendments brought in by the in the constitution, read with the section 5 of the State Act.
Yes,
Isn't it?
that right is already there.
Now,
protected.
reading the conclusion,
Yes,
it appears that while these amendments have not been interfered with, but there are a few conditions laid down in
Yes.
Nagraj
Yes,
as to how the amendment
yes.
is
And that
likely
has
to
been
operate.
elaborated by Ivy Goha's judgment. He clearly, the division bench clearly answered those queries.
How do you answer it? Let us.
Malad, if
Yeah. I think it is para 44 and 45.
yes, Malad, then I'll have to read 44.
44 is the just a reference to the clause.
From 40 onwards, from 37 onwards, but then I'll have to read.
Yeah.
Can I read? Because
Sure.
from 37, Lordship knows that 2002 is in operation. The argument of the government and private counsel rejected.
No. See,
The-
there
the-
is no quarrel that 2002 had given you some benefit. 2016 sought to take it away.
Take it away.
It was interpreted that
Yes.
it is not in superstition of 2002, but
Yes,
merely it lays down a procedure.
yes.
Now, that 16 has again been superseded by this 23.
28 means when the 16
So-
OM was gone, they did not want to comply, they brought the same OM.
No, we understand that.
Yes,
But what we need to know is
yes.
what is that which was sought to be implemented by 2002? What was sought to be
One,
brought in?
the consequential seniority.
Now, the consequential seniority will have to be understood in terms of 16 A, 16.4
16.4.
A.
Yes.
Now, 16.4 A has been interpreted by Nagraj at para 121 onwards.
Yes. Well,
Now-
it has upheld the constitution validity, and it talked about, elaborated on the excessive reservation. Our case is not an excessive.
No,
I-
that is what is required to be found out in this matter.
Yes. In fact, our case was never, because the Assam government, we never brought a case that excessive reservation was there and the reverse discrimination happened to the general. The general also never brought that case.
Okay.
The bone of contention, if I may say, hinges on one. The R.K. Sabharwal judgment basically said clearly.
So
that-
we are clear on this,
Yes,
that there's a
It's a
difference
principle
between cadre and group.
Yes.
We are clear on that. There's no problem with that.
My entire service career is finished by this cadre and rule, because what has happened, the rules are not being complied. That is the reason I asked the chief secretary, why is he saying promotion, let it go ahead as per grade? He could have used the word cadre because the chief secretary was informed about the judgment of Bhagwan Ivy Gohai. Because basically, Lordship, one thing is very palpable. The Assam government is trying to now wriggle out of this scenario because they know that there is no catch-up principle. So the OM of 2023 does not hold any water. Simply by bringing an OM, you cannot bring a dead thing. And in fact, the central rules, there is no such problem of this in the entire country. Well, this is a unique OM. In fact, I'll urge upon this that it should remain in history that this is one of the blatant exercise of power of overruling judicial. Well, para 40, if I may start. Division bench, Ivy go ahead.
Just a minute.
Yes. We have. Yeah. One cut, one cut. Who's calling? Who's calling?
Mr. Das will come back after just 1
Yes,
minute.
look, I look. Lordship, can I read from 40?
Yes.
If the determination of the quantifiable data is for adequacy or inadequacy of representation of the reserve category, candidates in a given cadre of a service in a particular department of the government, we are in agreement with the contention raised by D.K. Das, learned counsel for the respondent Bhagwan Pathar, that it would be more prudent and appropriate to undertake such exercise to the DPC itself before embarking upon a promotion process for a given cadre. The same would be prudent in as much as the DPC will have all the data before it as to the cadre strength of the promoted cadre, where the promotion is to be considered. And out of the total cadre strength, how many posts in the cadre are to be earmarked for the reserve category candidate? And out of the earmarked reserve category posts, how many posts are being occupied by the reserve category? In other words, if the reserve category candidates are occupying all the posts earmarked for the reserve category candidates in a given cadre, it can be understood that in that cadre there is an adequacy of representation of the reserve category. And in the event the number of reserve category in the cadre is less, then the number of posts earmarked for the reserve category, it would have to be understood that there is an inadequacy of representation in that given cadre. If the determination would be made in the above manner, we view this that we more appropriate and opposite for the DPC to make such determination. But again, such determination would have to be made before initiating the promotion process. As regards the third requirement of obtaining data, that is to harmonize with the efficiency in administration, we take note of the provision of the judgment of Supreme Court in Pavitra 2, wherein in para 126, it has been provided that efficiency in administration referred to 35 article cannot be construed on the basis of a stereotypical assumption that roster point promotees drawn from SC and ST communities are not efficient or their efficiency is reduced by appointing them. And secondly, the provision in para 116 of the said judgment, wherein by referring to the Constituent Assembly debates in respect of the position and third expressed by Muhammad Ismail Khan, no candidate, citizen shall be discriminated on account of religion or race, meaning thereby an interpretation is thought to be given that if across the board the reserve category candidates are considered to be inefficient or contributing to the inefficiency of the administration, without specific factual determination, it would be discrimination on account of race, which would be impermissible under Article 15 of the Constitution. As a determination of the quantifiable data on efficiency in administration across the board in respect of the reserve candidates would amount to a discrimination on account of race, which is prohibited under 15, we also have to hold that a requirement of obtaining data on effect of efficiency in administration because of the reservation of promotion method to the reserve candidate would be a violation of 15 of the Constitution and hence impermissible. as the three contention raised by Chaudhary senior counsel are answered as indicated above, meaning thereby as part
That you can skip.
as per the judgment of the Honorable Supreme Court rendered in paragraph 36 in Journal Singh 1, there is no requirement of obtaining quantifiable data as regards backwardness. And as per judgment rendered.
That you can skip. I think that has
Yes.
become redundant. I
Yes,
mean,
it is. become-
impliedly overruled.
And in fact, this court has also answered that efficiency also, because it will be a
Not
recess
required.
fee.
Not required.
So
Yes.
last part I have already read, the 44,
Hmm.
where he elaborates on clause 4. And then he says that this is in addition to what the judgment of.
No, this relevant paragraph is para 45.
Para 45 read with para 39. Because para 45 has to be read in para 39, because 39 talks about that it was with 37, that the 2002 is still operating. Because the entire bone of contention, your lordship will find from 2016, when the OM was brought by the Assam government for the first time,
No,
till
no,
2020.
that was at a stage
Yes.
when 2002 was sought to be superseded by 16
Yes,
without there being a very specific indication that it had superseded.
yes, yes,
So therefore it was interpreted that
Yes.
it did not supersede.
yes.
It only elaborated on the
Yes,
procedure,
Yes,
and it is open to the government. If they want, they can.
do or
pass
they
any-
cannot do, but there was a rider attached by the learned single judge
Hmm.
that it was not, because this matter came up before the division bench.
Therefore, para 45, because ultimately the division bench judgment has laid down a very specific
Yes,
finding.
yes,
If you come to para 46,
para 46, yes.
if you read that, after the cases are mentioned here, WPC 5, so
Yes,
and so,
yes.
so and so, then if you read,
I find it, but in respect of any other provision,
yes,
which may not be contrary or inconsistent with the provision of the judgment, the same will prevail.
correct.
Yes, but with a
Then-
further clarification, that if such provision of the judgment of the learned single judge is in conflict or contradiction to any of the provision in the present, such provision and judgment stands modified. Rightly so, because basically the single judge's argument was rejected by the respondent's argument was rejected that 2002 is the year. The entire argument of my learned friend in the other side is 2002 OM is overruled because of 16 and 2014. That has been negated. If that is negated, the section 5 immediately springs into operation and the 78 Act comes in.
But that is not answered.
Where?
Is that answered here?
So when the act is there, why an answering by the court is required? Matlab, the act is, there is no.
No, that is why we are trying to interpret para 45, understand para 45. What is para 45?
Yes, the Assam government has never challenged the 78 Act.
No, what is para 45?
Yes, para 45 is basically talking about that clause 4 is not permissible. Clause 4, he gave the parameters when it can happen. That when the posts are reserved, if after the posts are reserved are completed, there are some posts left. In that post, the reserve can always compete as a member of the unreserved. That is the settled position of law throughout the country. Well, we as reserve can go and compete on non-reserve posts. But the general cannot come and compete with us. So this has been the theme. In fact, the last part your lordship will say, see, I'll again read lordship, that part. Because an argument was sought to be made by the respondent that the last part also favors them. It doesn't favor them. How? Lordship will see. Lordship will come to the last paragraph. Office memorandum dated 12/3/2022. Has your lordship got it?
Yes.
But on the other hand, if the posts earmarked for the reserve categories candidates are already exhausted by being occupied by the reserve category candidates, but in the gradation list, there remain some reserve category candidates, they can compete for promotion against unreserved, but in such event, they would not be entitled to the benefits under consequential seniority. Here I'll wait, my lord. When we go up on merit, we don't want the benefit of consequential seniority. We are already above. And this is important. And on the other hand, he doesn't stop there. He continues. And on the other hand, if on the basis of their seniority otherwise, means seniority on a basis of merit, because when we go up, we don't go on, we go on merit. Without taking in note of the consequential seniority, they are within the zone, such candidate can be considered for promotion. Now, because of 2023 OM, we are shut out.
Now, what is the post that the petitioners or the respondents are competing for?
They are competing in all higher posts, like the engineering cases, they are competing for superintendent and above.
No, let us say in this particular writ petition,
Yes.
petitioner,
Oh, yes. He is now an additional, he is now a superintendent engineer.
so his next promotion would
His
be,
promotion was due, he was always above the list.
no, his next promotion would
Was
be
a
additional
chief engineer.
chief engineer.
Yes,
So his feeder category for superintending engineer was assistant executive engineer,
a feeder of is executive engineer.
executive.
Yes.
Now in the executive, how was he?
Yes, but
Promoted.
in executive assistant, executive till superintendent, he went in the cadre prior to his compatriots, the general. Earlier. He was getting,
Consequential seniority.
yes, everything, and cadre promotion in terms of rules, very compliant.
So
It was
now,
only in
now in this post of superintending engineer,
what has
his
happened?
position in the seniority
His
list
yes, in that case,
is higher.
he was already in number 2 of the gradation list. But what happened in January 18, 2023, the Assam government department said that now you will be brought back to 17 because we are taking not your cadre, the entire service career of your respondent junior in the cadre general. So all went up, all got promotion. I am finished.
Okay.
That is my case. In fact, I've been brought down. Well, only one exercise, well, I urge upon your lordship, and in fact, one judgment, if I may quote, I just find it. And I won't trouble your lordship much. Well, in Jarnail Singh, one argument was advanced, which is very much given. Well, paragraph 30, yes, paragraph 35(4). Well, an argument similar to the arguments of the respondents was brought in. That, well, I'll just make a synopsis, then I'll go to the judgment.
It's only
Well, Jarnail Singh 1. Listen,
क्या head note क्यों दे रहे हैं?
well, 2018 10 SEC
ये
396.
head note है.
2018 10 SEC 396.
1 minute.
Well, an argument was advanced. Well, before it comes, I can say, well,
Yes,
an
yes.
argument was advanced by the senior counsel appearing for the general that when you go up,
हाँ यहाँ पे है. Paragraph
paragraph 34,
34. Yes,
can I read, Chief?
yes.
We have already seen that even without the help of the first part of 16(4)(a) and 16(12) Amendment Bill, the providing of quantifiable data of backwardness which it comes to scheduled caste and tribe has already been held by us to be contrary to the majority judgment of Indra Swani 1. So far as the second part of the substituted Article 16(4) contained in the bill is concerned, we may notice that a proportionality to the population of the scheduled caste and scheduled tribe is not something that occurs in Article 16(4)(a) as indicated, which must be constructed with 330. We may only add that Article 46, which is a provision occurring in the directive principle of state policy, has already made the distinction between scheduled caste and scheduled tribe and other weaker sections of the council people. Article 46 reads as follows: promotion of educational and economic interests of the SC, ST and a weaker section. The state shall promote with special care the education and economic interests of the weaker section of the people, and in particular the scheduled caste and the scheduled tribe, and shall protect them from social injustice and all forms of exploitation. That being the case, it is easy to see the pattern of Article 46 being followed in Article 16(4) and 16(4)(a). Whereas backward classes in 16(4) is equivalent to weaker sections of the people in 46, there is the overall genus, the species of scheduled caste and scheduled tribe is separately mentioned in the latter part of 46 and Article 16(4)(a). This is for the reason that has been pointed out by us earlier, that SC and ST are the most backward of the weakest of the weaker section, and therefore presumed to be backward, since Dwivedi's argument that the member of the SC or the SC tribe reaches the higher post, he or she no longer has the taint of intouchability or backwardness, as the case may be, and that therefore the state can judge the absence of backwardness as the posts go higher, is an argument that goes to the validity of Article 16.4a. If we were to accept this argument, logically, we'll have to strike down 16.4a as the necessity of continuing reservation of SC and ST member in the higher post would then disappear. Since the object of Article 16.4a, B, A and B is to do away with the 9-bench Indrasani one when it came to reservation and promotion in favor of the scheduled caste and tribe, that object must be given effect to and has been given effect to by the judgment of Nagaraj, rightly so. 16.4a has been upheld. That being the position, case we cannot countenance such an argument that would indirectly revisit the basis of foundation of the constitutional amendment thereby themselves, in order that one part of Nagaraj be upheld, namely there is quantifiable data of judging backwardness of SC/ST. We may hasten to add that Dwivedi's argument cannot be confused with the concept of premier, which has been pointed out. It applies to SC/ST who is no longer required reservation, as opposed to posts beyond the entry level, which may be occupied by the members of SC/ST. So my argument is that the fact that they wanted to bring in the catch-up principle through the back door, deny us the merit as we go up, reduced our downgraded our seniority for no absolute reason, in violation of the service rule, because we as officers want that the service rule has to be. We never knew that after 25 years of service, one fine morning in the year 2023, all and 16, all our seniority will be brought.
Let me understand your petitioner's promotional graph.
Yes, yes. I'll bring that.
No, just we can just across the board we can understand. His entry point was assistant executive
His
engineer
entry was assistant executive
on the basis of direct recruit.
and direct report.
So in the seniority list, he was shown as position so and so,
So-
occupying ST or
Yes,
SC,
yes.
whatever he is. Next
Next
promotion is
promotion was
executive engineer.
assistant executive engineer.
Engineer
He started his first jump.
as the consequential seniority,
Yes, he started getting.
right?
He started getting. So he gets his benefit in the cadre in terms of the rule.
And therefore he was placed higher up.
Always gradation list, he was always as part of gradation list rules. In fact, the gradation list of the engineering service specifically says there shall be prepared and published every year a gradation list containing names of all members of the service cadre wise in order of seniority. Now they have completely done away with it. They have removed the column. Malad, in the Radhe Langthasa's case, second case, which I'll be elaborating, 665, it's very shocking that cadre column is gone. There's the mischief. They brought in date of entry into service.
No, we don't want to know that. We
Yes.
want to know his graph.
Yes,
See,
and then he moved.
the entry point,
Yes,
he gets the benefit of
consequential seniority
Seniority.
all throughout.
all throughout.
At 3 levels,
No, no.
I'll say level
No,
1.
no.
Yes.
Hold on. Let us say there are in the entry level, he was placed in whatever category, say serial number 10 in the gradation list. Now in the next higher post, let us say there's a vacancy of 2 vacancies, let us say, or 3 vacancies. Perhaps in the rules, 3 times the number of vacancies into 9. Now, if it is 9, by virtue of his seniority at 10, he ordinarily would not be included. Unless there is a consequential seniority to say that one post
On the
being
roster.
reserved or whatever it
Yes,
is
yes.
there, he's brought into.
Yes,
So he gets into the zone of consideration, he gets selected,
yes,
promoted to the still next higher post.
he takes that.
Now there, his seniority would again be as per the merit adjudged by the DPC
In that cadre.
in that category.
Yes, cadre wise. Rules are also very specific. And it applies to all the service, all my clients, same rule, parametric. So this is something incongruous that we gain our seniority in the cadre, and with a stroke of a pen, you bring an OM and you take away. Our 25 years of our going up the ladder is totally phenomenal. Many clients of mine who are in top of the post, they want that the fag end of their career, they get the higher post. That is their achievement. For no fault of theirs, when the constitution is clear, when the laws are clear, the rules are clear, they have brought down. On the ground, Assam government stand is one OM of 2020.
All right.
Then another thing which I like to elaborate on the affidavit which they have given, my lord, that has helped me.
Affidavit has not even come. How
Yes.
can you elaborate?
Yes, yes.
It's not even here in the file.
I don't know. They gave me possibly they wanted to take time today. That's the only, because that has been the trend, because I have always wanted that a matter should be abdicated. Mr. Chaudhary also agreed with, because this is festering for a long time. Extra, the affidavit which they have given. In fact, I'll not go to the affidavit. I'll just say one. In one of the affidavits, otherwise they will again. In one of the affidavit by the government of Assam says that promotion has to be cadre wise. It basically
No, no.
supports that.
The fact that it has to be cadre wise is no longer resenting, right? It's already
Not for the government, it is for us.
all right. They may be interchanging the words.
But we are valuable
Yes.
rights of our are now affected.
Yes.
And in fact, what I want to say that the 2013, this issue has been festering for a long time. In fact, when it started, when the 2012 amendment in Assam bringing in post-based reservation was brought. Because in India, it was in 97, post-based was there. Assam, it was, we lost 13 years. The Honorable Chief Justice wanted to know that what is the position of your stand on promotion. It was a categorical affidavit by the Chief Secretary saying we'll follow letter and spirit R.K. Sabharwal. If letter and spirit of R.K. Sabharwal, you have already admitted before the division bench to an affidavit that cadre-wise promotion will be the basis.
No, where is that notification again? 23?
Where, Lordship? Oh, yes, yes. OM.
OM.
I'll just. It is at page 107.
107.
Interesting one. In fact, my lord,
Yes.
Lordship wanted to put a question. Lordship wanted to put a question.
No, we want to go through
Yes,
this again.
Lordship, a very funny thing has happened in the year, in 15/3/2023, the Assam government in WPC 665, that is Radhesam Lantasa's case, has filed an affidavit where they say, where the secretary says that it will be cadre wise. And in fact, Your Lordship, if I may take Your Lordship to the stand of the Chief Secretary, this is the, it is on record, of course. This is the Secretary founder. Secretary founder, not affidavit. It is on private document. Yeah, that's a point.
Yes. Let us hear the respondents.
Well, I have one more clause I have not,
Okay.
because I
No,
have
we are not
checked.
closed. We are not closing your arguments.
Then, well,
But-
I have another clause, offending clause, that
Ah.
I will make my submission. What they wanted now through this OM also, they want to de-reserve our post after 3 years. Supreme Court in a case has said, once the post-based reservation comes in, it has to be, cannot be de-reserved, means the cadres will be fixed now. So the roster, there will be no discrimination, 100-point roster, 78 general, 22 reserve. So where is the question of de-reservation? They have done it. But I'd like to make my submission later. On this point, Your Lordship.
Yes, respondents who are there, respondent.
The task will.
Lordship, regarding this revision 363, we have for the water resource department has filed already affidavit in opposition, Lordship, in 363, Lordship. In Personnel Department.
Yes, Mr. Nath,
But we have filed the affidavit today, Mullah.
he has not come.
It has not, Mullah, we have extra copies, Mullah. We can keep.
Hmm.
keep Upasana,
No,
Mullah.
we'll get copies. That's not an issue.
Lordship,
But it is
Mullah,
not.
my senior Mr. D. Mojumdar is here, Mullah. He will just coming, Mullah. He'll submit. Let me give me 1 minute time.
All right, we are keeping it aside for a while. Is he here?
Lordship.
If I may, since Mr. Nath is, Mr.
Yes.
Yes, he also asked me that, well, can I finish the other clause de-reservation?
No, no, we are not curtailing your
Okay.
arguments. We want to know what is the stand.
Yes.
And then from
Yes,
whatever
yes.
you have argued,
Argued,
let
what
us,
is
we
this?
thought we'll hear them.
Yes, that will be.
And
next.
then we'll come back to
Then it's
you.
okay. Then it's
So this is
No,
how we'd like to proceed in the
Proceed.
matter. Otherwise, what happens is, you see, the things go,
Yes.
uh,
In fact,
things are being elaborated.
I'm very
Right.
happy that your Lordship had asked pertinent questions which I could answer.
We are happy that you have been able to enlighten us, take us away from darkness to light.
Well, darkness, light is already there in the form of two judgment, ATP. So,
No, that's quite right.
but I want to illuminate it further.
But if the illumination is too bright, sometimes it is difficult for,
Well, because they will try their best not to
right.
de-illuminate it.
We'll take it up
Yes.
at 2 or what? Or some other date.
He'll be coming.
No, no, he'll be coming. We understand he was here. Must have
Lordship, take a-
at 2?
Yes.
At 2. Okay.
Real question.
So this was that was the particular. Yes.
In this matter, we have submit our argument, Lord, but our
Who is for the accountant general? Is there any counsel for accountant general?
Fine.
You are appearing. Have you filed your counter?
not fine, Lord.
We'd like to know your views because apparently from the pleadings we find that you are unable to release the benefits because there is no fitment table. That is your stand. So we'd like to hear you on that. Who's arguing for accountant general? Who's leading you?
Mr. A. Hassan Lordship.
Where is Mr. Hassan?
I'll call him.
Follow him after some time. Or at 2. At 2 p.m.
At 2, my lord.
May I please, your lordship. Well, in this case, the department has yet not filed an affidavit. And additional, my lord,
Yes.
provisional pension has not been regularized. And pension period from 11/4/2007 to 3/1/2014 are also not been regularized. And so far, my lord, departmental proceeding is concerned, the imposing penalty of rupees 500 for the month for a period of 1 year imposed. And whereas, my lord, in criminal proceeding, the petitioner has been acquitted regarding the same
Yes.
the departmental proceeding as well as criminal proceeding was initiated on the same charge. Now in criminal proceeding he has been acquitted, but in departmental proceeding, this penalty has been
Response
imposed.
have not been filed. Who's for the respondent? Who's for the respondent?
Lordship, I'm for the accountant.
Mr. Goswami. He's putting to challenge that where charges are similar and he's acquitted, further proceedings not permitted.
Yes,
That is your case.
And question is, departmental proceeding, it is not proved. And so far inquiry report is concerned, only saying, my lord, that there is a possibility.
You are still under suspension,
No, my lord.
reinstated.
That reinstate, my lord. And only, my lord,
Where is the order of the disciplinary authority?
that is, my lord, page 93, my lord.
Lordship.
93 years.
Yes. Annexure P.
Where is the departmental, where is the inquiry report?
Inquiry report, my lord, that is page 56, my lord. Type copy.
56.
Yes, sir. 56.
Yes.
And page 58, last line saying that there is a possibility, not saying that proof. And inquiry report also failed to say that the witness, departmental witness was cross-examined. That is also not there. For departmental inquiry, this inquiry report and this order dated 19 is quite different. Order dated 19 December 2020 saying that charge level against the dealing head officer was proved. Whereas this report does not say.
হ্যাঁ, ভালো হতো না। পেপার পারলে তো। পিপি ডিপার্টমেন্ট করতো। দিয়ে দিয়ে করতো।
Yes.
Your Lordship, the inquiry report saying that deposition of witness shown, but whether they were cross-examined, that has not been done. And only, my lord, this inquiry report saying that there is a possibility and the proof quite different word. But order, departmental order, my lord, final order saying that the level against charge level against the delinquent official was proved contradictory. And here also, my lord, the similar charge level in the criminal proceeding failed to prove an acquittal. That is, my lord, criminal proceeding is higher degree, my lord, comparison to the departmental proceeding. And civil case decided on the basis of preponderance of evidence, while criminal case, the entire burden lies to the prosecution, and prosecution failed. And here
What are the charges?
only charge, my lord,
Where is it? Show cause notice, where is it?
only charge, my lord, this is forgery. Page, my lord, 47.
What about appeal? You did not file appeal.
Oh.
Appeal?
Against this, we made a representation, and against this charge, my lord, we submitted a written statement.
Formal appeal was not.
Formal appeal was not. And thereafter, my lord, departmental inquiry report submitted. And after, my lord, departmental inquiry report, the deputy secretary issued a letter addressed to the petitioner, that is page 68, saying that to submit a representation, if any, for consideration. And thereafter, we made a representation on 24/8/2010. This representation is to be treated to be appealed.
Page 59.
Section. As per letter dated 7th August 2010, this representation was made. And in this representation, it was stated that page 70, my lord. Therefore, from the above discussion, it is humbly stated that I believe the report of the inquiry officer is incomplete and the same is prepared without any record, information and evidence. So humbly I pray that I may be freed from the charge level against me, and your honor may take a lenient view on my family. My daughter, who has passed SSLC exam with letters in 5 subjects, and my son, who is studying in class 9, and withdraw the suspension order and reinstate me in my place of work. And thereafter, my lord, I was reinstated on 3rd January, my lord, 2014. This order, my lord. Reinstated 3rd January 2014, page 74. But due to this impugn order, my pension has not been regularized, and I have just of receiving provisional pension, my lord. And the suspension period also not been regularized. This is the case. And so far, my lord, inquiry report along with the evidence collected during this inquiry, my lord, has not been on record, my lord. That has to be called for.
Lordship may dispose of this matter, Lordship. So direct the petitioner to file a appeal before the concerned authority, as well as your Lordship may direct the authority that to dispose of the representation which is filed by him in an as enclosed here is Annex K.
What is the limitation for filing an appeal?
Yes, Lordship, it is one month.
That time will be
Section
over.
15. One month. 1 month. No, it may be relaxed. The period of
You want us to relax?
no, Lordship, the direction may be given to the petitioner. Direction may be given to the petitioner to file an appeal.
Which was the provision?
It's
At
15.
this stage.
It is up to 15.
15. This 1 month. So that's 1 month. 15. 1 5. 15 of
Or this
yes. But again, the question of appeal will come.
Yes, what is to be done?
Lordship, Lordship, this honorable court may direct the authority that to dispose of the representation dated 24/8/2010 or
Where is that representation?
Lordship.
Where is that representation?
Yes, page 69, Annex K.
No, that
Me-
was,
is it-
that was, my lord, prior to pass this final order. That was prior to impose this penalty. And after imposing this penalty, there was also a representation that also not disposed of. Page 94, my lord. Penalty final
You have filed another representation.
Yes, Lordship.
94
After, my lord, penalty dated 19 December, which is SL here, my lord, this impugn order, against this impugn order, after receiving this order, my lord, on 9 February 2021, page 94. 9 February, one representation was made. That also not been disposed of. This is also, my lord, held up. Pray for regularized suspension period and sanction of retirement.
This is for regularization of suspension period.
Yes, regular. This is the issue, my lord.
What is the issue?
Regularization of my suspension, because after passing this, imposing this penalty of rupees 500 for 1 year, and my pension has not been regularized. This is provisional pension I am receiving. And pension has not been regularized, and other benefit also. And therefore, this is the ratio residency in this case. So prayer for regular suspension period and sanction of retirement benefit. Penalty, my lord, is a minor penalty.
Oh, you get your instructions. We can't dispose matters like this. Get your instructions here.
Lordship, the GAD will,
Who is for GAD?
yes,
Yes, Mr. Nayak.
Lordship, my name is not appearing, although I am a party here, Lordship. I have not gone through the petition also.
You go through and get your instructions and see, there is a disciplinary proceeding initiated, some order has been passed.
Lordship.
Now he is retired in the meantime. Because of this order, there is a direction to release withdrawal of pension or at the rate of rupees 500 under Rule 21.
Lordship.
Now, under Rule 21, there is a procedure laid down, whether it has been followed, not followed.
No.
And you are not getting provisional pension.
Provisional pension I am receiving.
He is getting provisional pension after deduction of this
No,
amount.
Lordship, basically his pension has not been finalized and his suspension.
Because you are proceeding, you are directing in order under Rule 21.
Yes, that is withdrawal part. And his suspension period also has not been regularized. These two issues are there. Now,
These
Lordship,
two
one
issues.
appeal provision is there, Lordship, at Rule 15, Lordship. And 17, Lordship will get the limitation period. That may be extended also by the department if sufficient reasons are there.
We can do that,
Okay,
provided
Lordship,
department
I will obtain instruction.
takes a proper, decides the matter properly to consider the case. We don't want a rejection again coming back to the High Court.
The relaxation part is to be done by the department only, Lordship, not by
Correct.
the court.
But the
Lordship-
relaxation must be to the effect of, the purpose of that would be to hear the appeal and pass an effective order.
Lordship. In that case, Lordship, I am praying Lordship will grant me sometime, Lordship. Petitioner
But
will furnish
then
me a copy, Lordship.
where is the appeal?
Appeal has not been filed.
Appeal has not been filed.
Yeah.
Which authority?
GAD, Lord.
Appeal to be filed for who?
Appeal, it will be Chief Secretary, Lord. Order was passed by the Commissioner.
Do you want to prefer an appeal?
My lord, limited prayer, my lord, here, my lord. Prayer is, my lord, very limited for regulation of my suspension period and pension. And so far, my lord, impose penalty, that is, my lord, 500 for 1 year. This is the, and for this effect, my lord, my pension has not been regularized
Otherwise, it was a very minor penalty. Lordship will see
for 1 year.
penalty of withdrawal of pension at the rate of 500 only per month for a period of 1 year. It was an order of 2020 law.
But this affect my pension, my lord, regular. And the period under.
No, is it your submission that only orders, then you require an order only for regularizing your suspension period? That's the only prayer?
No.
Okay.
Suspension period is to be regularized and pension is
Now
to be
you are
regularized.
again starting with pension.
regularized pension period and sanction of retirement benefit.
Uh,
This representation. So, say 94 minor representation is to be disposed of.
94 is the representation to be disposed of.
Lordship.
You're happy with the disposal?
Lordship.
All right. We heard learned counsel for the parties. This writ petition is filed with the petitioner who sup- who rendered his services under the uh, Commissioner and Secretary, Government of Assam, Secretariat Administration, within bracket Establishment Department. Petitioner superannuated from service on
On, my lord, 36,
36,
2020.
2020. Stop. While he was working as junior administrative assistant in the PNPG department,
Junior administrative assistant.
administrative assistant, a criminal proceeding was initiated against the petitioner corresponding to GR case number 5416 of 2008. Stop. The competent court, criminal court, by order dated 14 February 2020, acquitted the petitioner from all charges leveled against him. So, during the course of the, in view of the criminal proceedings initiated against the petitioner, he was placed under suspension, and a departmental inquiry was also conducted. Stop. Show cause notice was issued with 3 charges, and the petitioner replied to the same. Stop. The proceedings were initiated and the inquiry officer concluded the inquiry. Stop. In view of the proceedings having been initiated against him, departmental proceeding, he was also placed under suspension by order dated 3rd January 2014. Sorry, 12/4/2007. Stop. Subsequently, by order dated 3rd January 2014, he was reinstated in service with effect from the date of his joining. Stop. The inquiry officer concluded the inquiry proceeding and on the basis of the evidence adduced, held that the charges have been proved against the petitioner. Stop. Where is the order imposing penalty?
93.
Huh?
Is
93.
93. The findings of the inquiry officer were upheld by, were accepted by the disciplinary authority, and by order dated 19 December 2020, the disciplinary authority having accepted the decision, findings of the inquiry officer, imposed the penalty of withdrawal of pension at the rate of rupees 500 only per month for a period of 1 year under Rule 21 of the Assam Services Pension Rules 1969. And the departmental proceedings have been held to be disposed of. Stop. Against the said, in view of the order imposed by the Commissioner and Secretary dated 19 December 2020, the petitioner having retired was not granted his pension and other retirement benefits, although he was granted provisional pension. Stop. Para Learned Counsel for the petitioner submits that in the writ petition he is a limited prayer inasmuch as that his suspension period was never regularized. As a consequence thereof, his pension papers could not be finalized and he has not received his pension after being retired for more than 3 years. Stop. You are receiving provisional pension.
Provisional pension.
He, however, submits that he has been receiving provisional pension. Stop. Learned Counsel for the petitioner submits that he
15,000.
did not prefer the statutory appeal as provided for under the Assam Discipline and Appeal Rules against the order of imposition of penalty. So, however, he had filed a representation before the Commissioner and Secretary. What is SAE Department?
This is Secretariat Establishment Department.
Secretariat Establishment Department, Dispur, requesting for regularizing his period of suspension in order that he may be entitled to his pensionary benefits. Stop. But it has been done. Page number 103, what is this over? Treated as on duty. What is 103?
This is also impugned, madam.
Huh?
This order also is impugned.
Impugned.
Yes.
Why?
Because this period shall be treated as on duty. Actually, he was not on duty. And the salary for this period shall be limited to the subsistence allowance as entitled. So this period has not been regularized.
It is submitted by the Learned Counsel for the petitioner that although an order dated 20 December 2021 has been issued by the department whereby his period of suspension with effect from 11/4/2007 to 3/1/2014 is to be treated as on duty for the purpose of pensionary benefit only, but the salary for the period is limited to the subsistence allowance as entitled. Stop. However, his period of suspension was not been regularized. As a consequence thereof, he has been deprived of his pensionary benefits. Para Mr. K. Nayak, Learned
P. Nayak, Lordship, I'm appearing
P.
for
Nayak.
1 and 2, Lordship.
appearing for respondent 1 and 2 submits.
Lordship, my submission will be, Lordship, as if the petitioner is not facing other prayers, Lordship, and his prayer is limited to the extent of regularization of the service period, Lordship. Matter will be remanded back to the department to dispose of his representative.
Submits that since the writ petition has a limited writ petitioner has a limited prayer before this court, namely for regularization of its period of suspension, the matter can be disposed of, directing the respondent authority to consider his claims and pass appropriate orders. Para. Having heard learned counsels for parties and upon careful perusal of the pleadings record, it is seen that the prayer before this court, although several prayers are made before this court in the writ petition, presently the writ petition is the council, the petitioner is pressing only the limited prayer of regularizing his period of service under suspension so as to enable him to get his retirement benefits. Stop. Learned counsel for the respondents do not have instructions as to the status of the representation dated 9th of February 2021. Stop. Under such circumstances, without expressing any without any view on the merits of the case, the petition is closed with a direction to the Commissioner and Secretary, Government of Assam, SA within bracket E Department, Dispur 46, to expeditiously consider and dispose of the representation dated 9th of February 2021, stated to have been filed by the petitioner. Stop. If not already considered and disposed of. Stop. If any order in the meantime has been issued by the department, then a copy thereof shall be furnished to the petitioner. Stop. With the above observation, writ petition stands closed. The respondent authority will dispose of the representation within a period of 30 days from the date of receipt of a certified copy to be filed by the petitioner.
Lordship.
My lord,
Lordship, the department is Secretariat Administration within bracket Establishment.
Secretariat Administration within bracket Establishment Department, Government of Assam, Dispur Guwahati 6.
my
Mr.
lord,
Rava appears for Accountant General.
my humble submission, my lord, regularized subscription period with consequential benefit, may note,
Sorry?
with consequential benefit.
It goes without saying. It goes without saying. Retirement benefits with all consequential benefits.
Shall
Apply.
benefit with
Dispose.
consequential. I love that.
May I please, Your Lordship?
Yes.
This case, Your Lordship, some instruction was sought from learned counsels for the Tezpur University, Your Lordship. Otherwise, the case, Your Lordship, is relating to withholding of the pensionary benefits, Your Lordship, of the petitioner on the basis of certain comments by the auditors, Your Lordship.
Yes.
Your Lordship, the petitioner retired from service, Your Lordship, on 30/6/2021.
Yes.
In fact, Your Lordship, he was initially appointed in the year 1995, Your Lordship, as an assistant finance officer in Tezpur University, Your Lordship.
Hmm.
Till 2008, Your Lordship, he was working as such, but in 2008, there is an advertisement for internal audit officer, Your Lordship. And initial 2 advertisements are there where no one could be selected, Your Lordship. Thereafter, the petitioner was selected, and on deputation, he remained there till 2013, 5/7/2013. And on 5/7/2013, he was again appointed as a finance officer on deputation, Your Lordship, in which course he continued till 18/8/2018, when he was again reverted back to, after completion of this deputation period, Your Lordship, to the post of assistant finance officer. And ultimately, Your Lordship, he was promoted to the grade of deputy registrar, Your Lordship, on 22/4/2021. And then on 30/6/2021, he retired from service, Your Lordship. Now, if Your Lordship comes to page 24 of my petition, Your Lordship,
Yes.
S 24, Your Lordship, got it. After this, Your Lordship, table, then the note, as per approval of the competent authority, an amount of rupees 20,77,976 is hereby kept on hold from the leave encashment retirement gratuity till settlement of the pending audit para number 2, 3 so and so of the inspector report on accounts of Tezpur University for the year 2018-19 issued by so and so.
Hmm.
Then Your Lordship will get that observations at page number 31. Observation is at page 31.
Yes.
Prisoner.
Read please. Para 2.3 irregular appointment to the post of so and so finance officer. Then paragraph, your lordship, first, second, third. From scrutiny of service records made available to audit, it was observed that Mr. Bani Pathak, the petitioner, applied for the post of IAO against the above advertisement number so and so. He was recommended by the Board of Management for the above post and was appointed in the post with effect from 14/5/2008. Mr. Pathak held the post of IAO from so and so and drew the pay attached to that post during the above period. Further, in March 2013, Pathak applied for the post of FO in the scale of so and so with grade pay of so and so again advertisement number so and so. As per the advertisement, the minimum educational qualification set for the post was master degree with at least 55% mark for equivalent grade of B 7-point scale. It is also mentioned the requirement of 55% marks shall not be insisted upon for candidates who are already in the university system, but the minimum marks required in such cases at least 50% of marks equivalent grade. As per MHRD letter number so and so post of FO shall be filled up direct recruitment for minimum post of master degree with at least 55 equivalent. So your lordship, only that ground, your lordship, this is the audit observation, your lordship. Based on this, your lordship, it was your lordship the held up, and in fact, your lordship, university has replied to that, your lordship, at page 43. Why I had to be appointed, your lordship.
Page 43.
43. For the post of internal audit officer, then ABC, despite wide publicity of the first two advertisement by advertisement number so and so dated so and so, no suitable candidate could be found. Under the circumstances, the Board of Management of the university in its 52nd meeting held on so and so took a decision to appoint Bani Pathak, who was then assistant finance officer, as the internal audit officer on deputation for a period of 3 years. So and so the term of appointment was later on extended for another period of years by decision of the board management in its 61st meeting held on so and so. For the Mr. Bani Pathak held the post of internal audit officer on deputation basis from so and so, Now, your lordship, this is the reason why I had been appointed. And in fact, your lordship, I have no role to play. I have placed everything before the selection committee, your lordship, and then selected. Now, my case squarely covered by the Rafiq Masi's judgment, your lordship, on the basis of which, your lordship, the authority has, the central government had issued an office memorandum also, your lordship. Well,
What is the grade of the post?
grade, your lordship, it will be grade 2, your lordship.
Grade 2.
Grade 2. And your lordship will, if your lordship goes to the Rafiq Masi, it says, your lordship.
Yes. Who's for the, you're for the university.
I'm very interested, madam.
So your stand is that no person was available, so
Yes,
you
my lord,
took
yes,
him.
my lord. Yeah, last again, the query was from this honorable court. They placed the before the court any decision order taken by this university for election and qualification of the petitioner next step, my lord.
Hmm.
My lord, we were already informed, my lord, by annexer the page 43 to the senior audit officer, my lord, and in the page 44 also, my lord, it is there, my lord. B, my lord, post for the post of finance officer. B, Bani Pathak was called for interview after condoning 2% of marks in master's degree by the competent authority, considering him as an internal candidate.
No. The question is, the objections raised are in two posts. Which is the higher post?
Lordship, finance officer.
Finance officer is the higher.
Those both the posts were, your lordship, deputation basis, your lordship.
Whatever. First you were internal audit.
Internal auditor.
There also you're not qualified because you did not have
Lordship.
the UGC norms.
Norms. 2%.
2%. Now subsequently again again to the post of finance officer.
Lordship. Your lordship will kindly come to page 44. That is the your lordship justification given by the university for the finance officer.
Yes. Now who is objecting? Accountant.
My lord.
Accountant General. So they have given their objection. They have given their justification.
Lordship. But during Lordship, that audit period, Lordship, that clarification was not given by the university, my lord.
Now they have given.
Lordship.
So now you take into account this clarification given and pass an order.
Order is to be passed by the office, my lord.
But as per the observation, my lord, this is was
On the basis of this observation, the university.
Lordship, during the
stayed it.
time of audit, Lordship, we found that, Lordship. That is why, Lordship, we have objected, and Lordship, accordingly, since they have given the clarification, Lord, we have
Now,
nothing to say, my lord.
now who is to pass an order?
Tezpur University is to pass the order, my
my
lord.
lord, we give clarification, my lord, to the audit, my lord.
You gave clarification.
yes.
Now, where is the difficulty?
My lord, is because of their observation, my lord, it was withheld, my lord. This said amount, my lord. So, my
You have
lord,
given your clarification.
Yes, my lord. So,
Is any
directly
further order
to the
necessary?
authorities, my lord, to put the authorities as well as university as well as the audit also, my lord. And immediately we can, my lord, so that
Huh?
we can release, my lord. Because of their observation, my lord, this we cannot, my lord. So,
In fact, audit objection is there, your lordship, but there is no direction that you withhold it. And in fact, your lordship, in Rafik Masi, para 18.4 says, recovery in cases where an employee has wrongfully been required to discharge duties of a higher post and has been paid accordingly, even though he should have rightfully been required to work against an inferior post. Cannot be done, your lordship.
and my instruction is, my lord, the honorable court with observation and give direction, I will, the university will.
Why should we give you direction?
Well, because of this.
Is it our responsibility to ensure release of payments to your employees? You take a decision.
because-
Why are you not
because
allowing
this-
to?
The audit observation is there, my lord.
No. Audit observation is there. That don't take a decision. Reject his claim. Then we'll pass a direction. You are the authority. You have to take a decision. Oh, you are throwing the ball before the court, comfortably saying that the court has directed. Why should we direct?
Because now the case is reported to honorable court.
No, then we'll dispose it off. You directing you to take a pass an order.
Yes, madam.
Yes, my lord.
You pass an order.
Yes,
Yes, my lord.
Yes,
Yes.
ma'am.
Taking into account your lordship. Rafik
Whatever,
Masi.
Yes, ma'am.
whatever is to be
That
taken into
observation,
account.
your lord- because ultimately, your lordship, I retired, my
Yes, ma'am.
retirement benefit, your lordship, around 20 lakhs, your lordship. And at least.
We'll give you liberty to pass an order. You pass an order. Writ petition will remain pending.
Lord,
Well, that will make some difficulties.
What
there.
difficulty?
So, my lordship may dispose of my direction, my lord, with this observation, this whatever we clear by the that will, my lord.
Either we can direct, we can pass an order, but we'll pass strictures against your officers for sitting over the matter. We'll pass strictures against your officer, registrar, and whoever is responsible here.
Well, in that case, my lord, I take instruction.
You take your instructions. We are not here to take decisions on behalf of universities and other central government bodies.
Yes.
Audit has raised an objection. You have given a clarification. Now you proceed in the matter. Who's stopping you? Is there a stay?
no, your
Then who's required to pass? The registrar.
registrar, your
Then
Register, my lord.
registrar.
you take your instructions immediately.
Yes.
We'll post it on 19th,
18, my lord.
18th. All right, 18th.
Lord.
Let them take a decision.
Lord.
We are not here to take decisions on their behalf.
Yes,
Lord.
If they pass an order, then you're further in your favor, then perhaps if we can close the writ petition. If they refuse to pass, we'll think of what orders should be passed.
Making upon a letter.
Mr. S.K. Medi, learned standing counsel, learned CGC, appearing for the Tezpur University, submits that further time is be granted to complete his instructions in respect of any orders that are required to be passed for release of pension,
Pensionary benefits.
pensionary
Pension I am
benefits
getting, your
to
lord,
the
retirement
petitioner
benefit.
in view of the clarifications submitted by the university in respect of the audit objections raised. Stop. He submits the matter listed immediately after the vacation. Then we'll have it on 22nd. We'll give him one more day. 22nd?
26.
22nd, I have some difficulties, and then February,
24th, your lordship.
up to 20.
All right, then on 18. 18. List on 18. Mr. Bhattakur for the petitioner, Mr. Talukdar for
For
the
respondent 4, my lord.
respondent for the accountant general,
Not
Yes.
accountant general, Director General of Audit, my lord.
director general of audit.
Deputy Observer.
Made your lordship. Well, the petitioner before lordship was placed on the suspension under rule 6(2).
Mm.
Well, he was arrested on 22/3/2023, and which week from that day only, well, he was placed on a suspension. He was released on bail on 24/4/2023. On 7/7/2023, the petitioner was asked to appear in a hearing in connection with his suspension.
Now, what has happened? Review not done.
Lordship, my humble submission before Lordship is that on being fair, Lordship, although he is on bail, he's not been acquitted anywhere, that's being reflected from the petition. The instruction we have been receiving, Lordship, me as a reader, Lordship, that is very surprising, Lordship, that the action of the petitioner as alleged in ACB PS so and so indicates gross misconduct while discharging his duties as a public servant and directly related to moral turpitude and continuance of the petitioner in his service is going to embarrass the government as well as affect the investigation. Hence, the ADC Viswanas has rightly passed the order of suspension of the petition from service for the purpose of fair trial of the case is that is about. I mean, that means the criminal case. But in this specific instruction losses, the para, nothing has been mentioned in regard to the discipline proceeding, at what stage it is there, whether any inquiry person has been engaged, any inquiry report is there, nothing has been mentioned. So that part is Lordship.
Who is to give you that instruction?
Basically under ADC Lordship,
Under
ADC, because he has been suspended by
ADC.
ADC.
I have made a categorical statement, my lord, under paragraph 6, that no disciplinary proceeding has been initiated, no review has been made till date. And
True.
my lord, as per my lord, Ajay Chaudhary, as well as my lord, Rakibuddin, I have entered to the reinstatement. my lord.
My humble submission before Lordship is that Lordship, this criminal proceeding and this departmental proceeding, they are two separate, and both has to go parallel also. They have no business with this. These two proceeding has no business with each other. So one opportunity may be given to them, Lordship. Let me get some specific instruction in regard to the status of the disciplinary proceeding. And if not done, then definitely, Lordship, there's a
Already
major lapse.
two opportunity has already been given, my lord. He is under suspension since last month.
Is he not receiving subsistence allowance?
He is getting them.
Then
But my lord, almost 1 year, my lord.
if you are reinstated, you'll get back everything. Mr. Hart, Mr. Ait Soikia, Learned Counsel to the petitioner, Mr. CKS Borua, Learned Cabinet Advocate, who submits that complete instructions in respect of the status of any disciplinary proceedings or review conducted regarding the suspension of the petitioner has not been received. He prays for further time. Please take it on. Prayer made is allowed. Please take it on.
Absolutely.
Reopening
5th of February.
Absolutely.
6th of February.
Absolutely.
You get specific instruction
Lordship.
on that.
my lord, to observe that my lord, on the day, my lord, if no
Not necessary. We'll take up. You renew your prayer.
My Lord.
Yes.
Matter relating to the suspension of the petitioner.
Why is it come for orders?
Actually, it should have come for admission hearing.
You have filed some additional affidavit.
Yes, long backlog.
Any response from the respondent side?
No.
No, my lord, not yet.
Until the lordship, there is no review.
No, you get your instructions. We are taking it up on uh, 7th of February. 7 February
February for admission here.
for admission.
Yes, my lord.
Mr. N.J. Khatoniar, Learned Standing Council,
Secondary education.
secondary education is permitted his permitted further time to complete his instructions in respect of any disciplinary proceedings conducted against the petitioner or any order of review or suspension, whether passed against by the respondent.
Lordship, they have instruction that there is no review till the Lordship. Affidavit may be given. Instead of, they have instruction. On last occasion, they have put in instruction.
Let the matter be listed again on um, all right, on 7th, Mr.
Obliged.
S.K. Sinha for the petition. 7
admission
February
For admission here.
for admission hearing, yes.
Obliged.
For admission.
Yes, please, this is a case of that the PSO providing PSO. We are enjoying that we are getting the PSO services after paying that monthly allowance that remuneration we are paying on the cost basis. Now they have filed. They want that the PSO which has been provided to us shall have to be withdrawn, and they have filed one affidavit today also. We have to go through it. So
So
let
in
that-
in the affidavit, we have brought on record the last two the SSRC minutes on record. No? The last SSRC held on 30/6/2022 and 19/10/2023. That has recommended that no PSO should be given to the petitioners. Lordship fixed the matter on 18th or 19th. No?
There is an interim order.
Yes, that interim order
on
is
the basis of
But
the
another thing, my lord, I want to
on the
point
basis
out,
of the interim order, they are enjoying the PSO. No?
we are enjoying the PSO, but what happened, my lord, I want to point out, so my petition is my client, so far my person petition is concerned, that when he, that the money, that have to be paid through
Interim order was passed on which date?
interim order. Yes, my lord, I'm just saying. Interim order is passed on, the justice. একটু heavy ছিল রে, শুনে তো judgment ছিল রে। 59/2017, I think.
59.
59 is before that date, where that registered to post this case again on 59. So that date before that 59, that should 10/8. Found in the Justice Sumon Sham.
10/8.
Yes.
2017.
2017.
Well, Lordship may kindly take up WPC 3267 of 2017. My learned friend appears in this case for the petitioner. 3267/17.
10/8. There is no 10/8 order.
2017.
3267/2017.
Yes. No, 10/8. There is a 10/8 order.
Yes.
2017.
Yes, my lord.
So,
The order is given like this.
one PSO on payment basis. until further-
But where is that 10/8 order? It is not available here. That's what we are trying to find out.
My lord, I can give you this copy, my lord, if your lordship wants.
Ah. But in which matter was it passed?
In all enter.
But it is not available here. It must be tagged in one of the
No.
matters.
It is past, yes, 3267, 17.
It's not here.
10/8/2007.
Okay.
So what we want, my lord, they have filed an affidavit today, so we have to go through it. And if present, we have to file a rejoinder.
But we filed the affidavit yesterday. We filed the affidavit bringing on record the minors. Let them go through, madam, and kindly fix the matter on 18th or 19th.
It is
Because yes,
submitted at the bar that an affidavit
My lord, 19.
filed by the government.
after 18th or
You filed it today or yesterday?
yesterday we have filed.
Yesterday. Stop, Mr. There are different councils.
They have a different counsel.
Yes,
Learned councils for the petitioners submit that they would like to complete their instructions in respect of the affidavit stated to have affidavit filed and by the respondent.
we
Government.
filed the affidavit in 5733 of 2017. And
Stop.
bringing the minors, I have given copy to the other council.
Learned Government Council submits that the affidavit is essentially filed in
5733 of 2017.
5733 of 2007.
17
Although copies have been served on all
to the other council.
respective councils appearing in all the writ petition. Stop. Accordingly, in view of the prayers made, let the matter be listed again.
On 18th.
My lord, 18, 19, I will be not there, but the other council also has some objection because.
Can it be in the second week of February, my lord?
Yes, second week of February will be better.
But we have some urgency because the SSRC has
No.
recommended on two occasions.
India, what this is, they could have given earlier. So today we have received the copy.
Let it be on 9th. Let us see what happens.
9th
9th of February.
Yes, madam.
9th of February.
Let the matter be listed on 18th or 19th.
Why?
Then let them come up because the SSRC on two occasions.
You filed it yesterday,
But only bringing the minors. on
whatever it
record.
may be,
Minors
but
on
they're
record.
entitled to being given some reasonable notice. In a matter of 2012 or 13 or 14, you have filed it yesterday.
But the minors have been brought on record.
Then
That-
Whatever it may be.
Yes, then we have to go
The
through it.
minors says that
If they're not important, why did you file the affidavit? You have brought it on record, you have served them copies,
Kindly-
it
kindly
should be
take-
given some
kindly-
reasonable time.
on 19th, kindly take it up on 19th.
Possible.
My lord, a copy may be given to us
Yes,
also.
yes, we'll give.
Copy has not been sub.
Yeah, give. I have already given to some, but I'll also.
Learned councils are at liberty to share their emails to the
Yes.
office of the senior government advocate, upon which the office of the senior government advocate may share
I'll-
or will share
Today. sure.
the soft copies of the affidavit stated to have been
Not-
filed before the court yesterday. Stop. Registry is also required to trace out the affidavit stated to have been filed and connect it to the corresponding case record. Stop.
It is on
Matter
record.
again on let it be on 5th of February.
14th.
My lord, we have some difficulty on 5th, my lord, my senior will be out of station, my lord. Can it be on 9th or 9th, my lord?
9th is better.
Ninth.
They
All
only-
right, let it be on 9th.
9th, my lord.
9th February.
I have also forwarded.
I'm deeply
Ninth.
obliged.
My lord, I will just point out, they are making some, Home Department is making some trick, my lord. They are not taking that out of the money which when